Hello, I'm Nikolaos Sitaropoulos. I'm head of division in the Department for the Execution of Judgments of the European Court of Human Rights. In this very short video, I will try to give you some basic tips for submitting and drafting communications under Rule 9 of the Committee of Ministers for the DH, the Human Rights meetings. The four basic words which you should have in mind when you want to submit a communication is construction, clarity, concision, and timeliness. That means that a communication should be well constructed, should be clear, should be concise, 5 to 10 pages max, and be timely. It is useful to make clear in the beginning of the communication its aim. For example, is the aim to comment on the scope and content of the respondent state's action plan or report, the implementation of the measures set out in the action plan or report, the respondent state's assertion in an action report that execution has been carried out so that the case can be closed, or procedural issues, such as whether the case should be moved by the CM from the standard to the enhanced procedure or rapidly needs a detailed examination because, for example, of intervening events. As far as the substance is concerned, that is the general measures. General measures aim to put an end to continuing violations and prevent recurrence of violations similar to that found by the court in its judgment. So it is important that you indicate whether the measures already taken or envisaged by the respondent state in the action plan or action report are sufficient for the purpose of execution or whether additional measures are necessary. If not, you should identify clearly what needs to be changed. There is an added value also if alternatives to general measures which are proposed or envisaged by the authorities can be presented in your communication. Bear in mind also that expert advice may be available from Council of Europe or other international bodies or institutions, and this kind of advice, it's not always useful to repeat it in your communication because these kind of documents usually are taken into account already by the Secretariat in the notes that they prepare. As far as timeliness is concerned, you should bear in mind that the respondent state is required to submit an action plan or action report at the latest 6 months after the date on which the court's judgment becomes final. The national reflection procedure should therefore start shortly after the judgment becomes final. The views of national human rights institutions as a result of this may be useful at an early stage, if possible a few weeks after the delivery of a judgment by the court. Now, if you want to target a case which is on the agenda of a human rights meeting, a specific human rights meeting, you can always check the preliminary draft list of cases proposed for detailed examination for the next CM human rights meeting on the homepage of the Execution Department's website. The list is available online after each CM human rights meeting, together with a list of cases listed for detailed examination at future human rights meetings by decisions of the committee. All communications which are received from national human rights institutions or NGOs are sent by the Council of Europe Secretariat to the state concerned. If the state responds within 5 working days, both the communication and the response are brought to the attention of the Committee of Ministers and made public. If there is no response within these 5 days, the communication is transmitted to the CM but is not made public, and it is only made public 10 working days after it was sent to the state together with any response received. As a result, you need to ensure that any communication relating to a case due to be examined at a specific CM human rights meeting is sent to the Secretariat in due time for the meeting or at least 5 days before that meeting to allow it to be taken into consideration by the Committee of Ministers, and more than 10 days if the intention is for the communication to be published by the Committee of Ministers. Now, if you wish that your communication is taken into account in the drafting notes on the agenda prepared by the Secretariat in respect of each case, it is important that the communication be submitted well in advance to the Secretariat whenever possible, at least 5 weeks before the CM human rights meeting.